Hello friends, Namaskar. Today we are going to discuss an important perspective, the perspective of your false implication in a rape case. Basically, in India, there is a misconception that doing sex with a woman is a crime. Do you know or believe that doing sex with a woman is a crime? If yes, then you are really under a misconception. So I want to remove your misconception and I want to address you in the light of law so that you could update your information and could act accordingly in the right way, in the legal way. First of all, I request all of you to maintain a proper notebook with pen or pencil to update the right information. Note down at the top of your notebook the word rape. First of all, we have to understand what a rape is. Doing sex with a woman is a rape, do you think? If you are thinking about the same, then you are having the misconception. Rape is defined in BNS. Rape is doing intercourse by using penis or by using any object with a woman against her will or consent. If there is a consent, but consent is obtained by putting her or anyone under fear or caution, or we know that she is put in a state of intoxication deliberately. Due to this, she is totally unable to understand the nature of it. And apart from that, she is of unsoundness of mind, and that's why she is totally unable to understand the nature of it. In addition to this, she is underage, means the age below the 18 years. In that scenario, it would be a crime otherwise not. So, if you are having a sex with a woman who is not unsoundness of mind, who is not intoxicated, who is not put under fear of coercion, who is consensual or doing the same as per her willingness, and apart from that, she is about the age of 18 years, then it would not be a rape. So basically, consent or willingness are the prime protocols to determine the rape in addition to other factors, and apart from that, the age is also the determining factor as well. So if we are going to do a sex with a woman, we have to assure that she is above the age of 18 years or not. If she is not, then we might be in a great trouble. So avoid panic from your life, be cautious, and apart from that, we have to be very much careful while doing the same. So today I will discuss the preventive measures and will discuss the defense strategy in case you are implicated in a false rape case. The preventive measures means to protect ourselves from being implicated in the false rape case. In today time, we might have girlfriend, we might have calm alibi, we might have female employees. There might be a relationship turned into a physical relationship, and ultimately there is a consensual sex, but for what you will be booked a rape case, which you had not done. But due to the problem of understanding between you and concerned police, they will always consider you as a rapist. That Mr. You have done the rape and that's why you are booked. You may say even to them that sir I have done nothing. But what they will say, you have done everything. They will consider you as a criminal despite the fact that you are not a criminal. So preventive measures are sine qua non to have the proper protection in form of anticipatory or questioning in case the police is not going to understand your grievances on the theory of misunderstanding. Because deliberately they are doing the same and deliberately they are causing misunderstanding so that you could be much more panicked, much more humiliated and can proceed yourself towards a compromise so that the girl could get a private compensation from you in term of money. Do you want that a certain money means 30 lakh, 50 lakh, 1 crore to be taken from you in the name of compromise? If you do not want, then the preventive measures are quite important for you. The first preventive measure is that first we have to determine the age of girl. If she is under age of 18 years, do not have sex with her. Because in that scenario, even though she pleads that there is a consent, but law assumes that there is no consent. So you will be in a great trouble and panic situation. Number two, assure about her mental health. Number three, assure that there is an agreement between you and her. That is usually called live-in agreement, which is very much easier to write. No need to be in panic or worry. Just have a stamp paper, narrate the terms and condition, and duly signed by you and that girl. And you may also take the help of notary to have the proper execution without any worry. Specify that you are not willing for marry, you are willing just for sex, and she is also willing for sex. So there is a mutual consent attribution regarding the same. Apart from that, maintain photograph and video. But remember one thing, sometimes we maintain the photograph or videos of private scenario or private place. That is wrong. Because if you are having naked photographs or captures in your mobile phone, then she may take the plea that by showing the photographs which are totally naked, you inter alia compelled her for sex or extorted the concerned lady for money. So, despite of that, you are required to maintain those photographs that showing the genuineness of consent and willingness. Means if you're going to a temple or any place or any public place, showing the mutual bonding, showing the social activities, etc. Apart from that, you are totally bound to maintain the chattings and the voice notes so that we could show the case of consent. Otherwise, you will be in the hot water. So these are the preventive measures. And in case the FIR is lost, then there is no need to worry. First of all, you have to ascertain the facts from the FIR. What facts she had narrated. If she has narrated false facts, then give the reply to the same to the concerned police. That is called representation. In the meanwhile, you are not advised to move for anticipatory or for questioning. Because without giving the proper representation, we would not be in a position to convey our points. And our advocates might say to us, do not do such practice. This will definitely affect your defense. But the key point is that if you are keeping silence, then it will amount to admissions. So if there is a false FIR, just file the proper reply with supported evidences. In addition to this, we have to emphasize in our reply that the lady is mature. She is about the age of 18 years. She is sufficient to know the nature of it. Apart from that, she might resist. But there is no mark on her body, on her private parts, and apart from that, medical evidences are not supporting the case of consent prosecutory. So these are the important vital points to be pleaded even in our representation. In addition to this, if there is a charge sheet, we may submit the said points to the consent court in the form of discharge petition, and even we may take such points as defense point in the course of trial. The submissions are sine qua non. The prime submissions are she is about the age of 18 years, as I told earlier, she is matured, she is having sufficient prudence, she is not resisting, there is no injury on the private part or her body, and apart from that, the medical evidences are not going to corroborate the same. The points taken earlier are to be repeated again, and in addition to this, you have to emphasize regarding delay in the medical examination. Sometimes it is seen that the examination is done with a delay of 21 days, 30 days, 40 days, 2 months, 3 months, 1 year, 2 year. So these are the beneficial point for us to be remembered. And apart from that, we have to emphasize on the point of inconsistency, on the point of delay in the FIR, and the non-explanation of delay. If delay is not explained, then it is very much beneficial for us, and we may take the same as a good defense point. In addition to this, the position of DNA, the position of other medical scenarios on record to corroborate her testimony. If the testimony is not corroborated by any witnesses, and apart from that, the present witnesses are hearsay, and the medical evidences are not going to corroborate the same along with the DNA profiling, in that scenario, we could have the benefit. So the said scenario is also get its strength from the important judgment of Honorable Punjab and Haryana High Court, which is recently propounded on 14th of June 2024. In that case, the consent Kamali Bai had lost a false case, and all the points which I discussed with you had been taken by that point, and ultimately the proceeding had been closed. So I am going to emphasize on the point that the consent is the important protocol, but this protocol will come into motion when you are having the proper protocols with you. So the protocol of lodging the report delay, so the protocol of non-explanation of delay, so the protocol of delay in the medical examination, non-corroboration, inconsistency, lack of any evidence that could sustain the factum of rape are the important key point for defense. So all these points are to be pleaded, to be put in during the course of trial and other proceedings so that we could secure either questioning or an acquittal. So I think that I'm totally able to cause all of you to understand the basis of preventive measure, the basis of defense strategy concerning a false rape case. If this video sounds you good, please share this content. See you in the next video. Till then, Jai Hind, Jai Bharat.